the issue with my investigation. He had been farmed out. He had over 200 H-1B people, and he had them farmed out all over the country and was not getting new LCAs. Okay, so let's continue. We have failure to offer equal benefits or equal eligibility of benefits. So you have the same rights as the U.S. workers. Misrepresentation of material facts. That's incorrect information in their application. Failure of providing working conditions as required. Let's see, filed an LCA during a strike or lockout. So you can't be required getting workers when there's an actual strike. Failure to provide notice of filing of LCA as required. Failure to accurately specify on the LCA. Failure to comply with displacement protections for U.S. workers, which is 90 days before and after date of the filing of the petition. Failure to take good steps in recruitment. They have to recruit local workers. Displacement of U.S. workers. So the Department of Labor feels, okay, this is a special visa, but you have to spend some time actually looking for American workers. After that time is done, then they have to treat all the workers equally the same. So you're going to have the same benefits as a U.S. worker. Required accepted payments of additional petition fees. Required or attempting to require penalty for cessation of employment. So when you get your H-1B visa, and you have your contract with the employer, they can't charge you to terminate the contract early, okay? They can't charge you for fees. They can't discriminate you for working there, for filing with us. You can't fail to make available for examination the LCAs. All these visas and H-1B different forms and LCAs have to be open to the public for us to look at. Everybody has to be able to, there has to be what we call public access files. Failure to maintain documentation as required, which includes the payroll, the time records, and all of these different forms.
In the public access file, what she was saying means your LCA, you can ask a copy of your LCA.
You should get a copy of your LCA.
You should get a copy of LCA because most of the employers won't give you. But what
And
public access, in fact, your grandmother can go and ask for a copy of an LCA. That's what a public access file is.
Yeah.
Anybody can ask. It's
Right.
your LCA.
Right.
It's a public document.
And it should be in order, because there's nothing worse than coming in as a mess. Yes?
What is LCA?
It's the labor condition, where you get the
Application.
labor condition application. So with, Yusuf will talk about it, but when they get the forms in, or maybe we'll talk about it, they have a specific labor application that talks about, like it's not going to be just related to you, but it's going to talk about the job title that you're going to have or the job duties that you're going to have. It's going to talk about the level of expertise and what they're going to be paying, and it's going to talk about the location. And I think last time I brought an LCA to show, and I think I forgot. I'm sorry. Next time I'll make sure I brought. I was looking for whatever I brought last time, and it was kind of coming up with new stuff.
And LCA is the agreement between, that's what she's trying to say, it's between your employer and the Department of Labor. So he can't get a contract with you. He needs to pay you. If he's telling you he's going to pay you
$60 an hour.
Yeah.
He better pay you 60.
He better pay you. He can't come and say, we'll negotiate it. He can't do that.
And he can't pay you $30 an hour and then say, I'm going to pay you $30 in a bonus. Like the Department of Labor doesn't look, it's all tax, not bonus, but a per diem rate. Like the Department of Labor looks at taxable income as wages. So whatever the LCA says is what they need to pay you. Okay. Okay, so now we're talking about 62G, which is a prevailing wage, which is really important. We have all these fact sheets for you guys if you're interested. Mitesh can email them,
Yeah,
right?
I will email
And
them.
it's a packet. And this is just very quick information. Obviously, you always have to refer to the regs. But we're talking about the prevailing wage and the guaranteed wage. So the prevailing wage is the wage rate set for the occupation classified in that area. So like the LCA will tell you, this is what should be getting paid. And then so you have then the actual wage and the required wage. And all those are going to be in the LCA. Okay.
And the prevailing wage means, the minimum wage, is that right? The minimum wage required in that particular state for your bachelor's degree holder, master's degree holder. The actual wage is, what your employer is telling you to pay. Mm-hmm. And whichever is higher is what you're getting paid.
The required wage, right.
So let's say if the minimum wage for your degree in this state is $55,000 and your employer can't pay 35
Right,
because that's the provided wage. But he can pay 75, that's fine.
right, right. So there's basic, they have to do some research and figure out what is the prevailing wage for that area, what is the required wage, and then what is the actual wage. And the actual wage is actually what they have to pay you, which has to be the higher wage. Okay, now we're talking about, so this is a good information about the prevailing wage. The nice thing about H-1B is that you are going to be getting paid a good wage rate because it's what we considered skilled. So you're going to be not looking at like the minimum wage, which is $7.25 federal. You're going to be looking at higher rates because you're going to be coming in with the skills that the employer here in the United States cannot find. So they're going to be looking to pay you a premium. Okay, so then we have 62H that deals with cannot ask you to pay. And this is important because sometimes employers think, well, you know, this person's coming in on this visa and, you know, they're vulnerable, they're going to do whatever it takes because they just want the job. And so you need to realize that the employer cannot ask you to pay for certain things. Those are the cost of doing business for the employer, and that you should not have to be paying for these things. So basically, in summary, the penalty they cannot ask you to pay for a penalty for completing their employment period. They cannot ask for any part of training or processing fees imposed by Homeland Security to get the visa, any part of the statutory $500 fraud protection fee imposed by USIS, any deductions for the employer's business expense to include attorney's fees, related filing fees for the LCA, filing the H-1B visa forms, tools and equipment, travel expenses for business. So they really have to, that's the burden of the employer. But I have found when I do the H-1B investigations, that some of these fees are then parlayed into the employee. And they kind of do it, like you talked, in a very sneaky way. They are like, oh, well, you know, you really want this job, so I'm going to, we'll figure it out. I'll pay it and you pay me back.
Your application processing fees and, he can deduct all those things from your salary.
Or ask for it in cash.
Yeah.
Because, I mean, we look at the payroll, and sometimes if the employer is not sophisticated enough, he's going to take it off on your payroll, but we see that. So they're going to, when we go in and we interview an H-1B employee, there's like, I don't know, 50 or 60 questions that we ask. And a lot of it has to do, some of it has to do with these fees, and are you getting paid the correct wage, and, where did they recruit you, and how did it happen? So if you are involved in an investigation, don't be scared of the questions, because I know they're intimidating, but they really are for your benefit. It's for us to understand if this employer is actually following all the rules that are required under the H-1B. So let me see. To summarize, obviously the most important thing is the place of employment and the corresponding LCA is very important because the LCA dictates what you should be getting paid, and that every location has a prevailing wage. A new LCA is required if the H-1B employee is working at locations more than 30 days. So if they move you around and you're there for 60 days, they should be getting a new LCA, okay? If they put you out on a temporary duty for 10 days, 15 days, that's okay. And that happens, especially in IT. So we have H-1B to the CFR, which is actually a good place to look in. Code of Federal Regulations is 20 CFR 655-700, and that deals with the actual laws of H-1B. And of course, we have the ATA 9035, non-employee specific, the attestations and promises, and requirements to be given to the employee. The I-129, petition for non-immigrant worker, is employee specific with qualifications. I mean, no, users going to be talking about that. I-797, we look at all those forms. Notification of action, which is the employee eligibility, date to work, and employer wage obligations to date.
When you get a chance, you guys can, send the forms to you. The reason that all those forms, she's telling quickly because these are the things that she needs to make sure that you're safe.
Right, and you should be getting a copy of these things.
And that's why, did you talk about benching?
Oh, thank you for mentioning. That is another one big violation that we find, which is called benching. And benching really means when you're here on an H-1B visa, they're promising you work for all the time. So your visa is for so long, they have to pay you regardless if there's work or no work, okay? So let's say that the H-1, that your employer says, well, you know what? I'm not gonna have this, I don't have work for these 2 months. I need you to take a vacation. Well, that's not really right. You take a vacation because you want to take a vacation when you need to take a vacation. But if they don't have any work, they have to pay you for that time. And that's actually one of the #1 violations that we find a lot.
And that's why this LCA ties into it, because this whole story ties very simply. You have an LCA, the employer promises with the Department of Labor that I'm going to hire you, paying you this much for the whole year. Period. Whole year. There's no 1 week vacation, 2 weeks I don't pay. You know, I go to a project, when the project ends, I will come back later 3 months and start getting paid. Because when she runs the investigation, she's going to see all those missing paychecks.
Right, right.
And that's what gets you in trouble. Right?
And what you want to do is you don't want to get kind of tucked into letting the employer tell you, I just need you to write a letter, because I'll ask for that. I'll say, okay, I need to know when they're on vacation and their vacation request. You don't want to be tied into lying about this, because really at the end of the day, it's harming you. I mean, if I get something that looks reasonably, you know, like it's verified that it's correct, and it says I'm on vacation to, you know, South America for a month, well, I'm not going to question it because I'm going to think it's correct. But if the employer doesn't have it, and then I interview you and you tell me, no, I've been here the whole time, then he's going to have to pay you know, for that time frame.
And
So-
if things like that happen, the reason she's here is you can call them.
Yes.
And they're not going to say, hey, you know what? Did you tell this person? No, that's not what they're going to do. So, and then your employer says you're fired. It's not that easy to do all that.
No, it's gonna be confidential to the maximum extent possible. The way I run my investigations is basically I take all the information, I keep it confidential, I approach the employer, and we want to look at both sides of the story. Because everybody has a side of the story, and sometimes, you know, one perceives it one way, one perceives it another way. But at the end, if we cannot get the violation unless we get permission to use names, that's when we get the permission, you know. And at that point, you might have already decided you want to work somewhere else anyway.
And then you should be able to move on. You know, they will give you the proper documentation. You know, I can't say, oh, I won't pay you. If you ask me to pay, I will fire you.
Right.
That ain't working.
Right. But they will do that. Some
but they
employers
would,
will do
they
that.
would, they would
Because
do
they
that.
take advantage of the fact
And
that
you
you're on
would
a special
have,
visa.
and that's the purpose of the event, because then you can call one of us, see what options you have. Believe me, as long as you're legitimate, you'll find your ways out.
Right. So, any questions, concerns? Kind of wraps it up for me, yes?
And when I want to go to vacation for 1 month in my country, they don't have to pay me, right?
No. If you're going because you want to go on vacation, they don't have to pay you. And sometimes, you know, because you are an H-1B visa, I mean, you are going to be traveling along. If you're a foreign person, you're going to want to, if you go home, you don't want to go for the weekend. And it's understandable. You're going to want to go for, you know, 2 weeks, 3 weeks, depending on how far you are. And that's absolutely correct. If you don't work, you don't have to get paid because you went on vacation. But if they don't have any work for you, they have to pay you. Because that's kind of, does that make sense? So the work is available, or not available, they have to pay you. Because you're here to work. So, any other questions, concerns? No? Yes?
About the vacation, what if the company or wherever you work asks you to go on the vacation? You used to get paid for going.
Well, that's a very tricky situation, and that really depends. I mean, they cannot tell you, okay, I need you to go on vacation because there's no more work, okay? That's where you have a problem. Now, if you know that, you know, you're going to be going on vacation anyway, that's where it becomes a fine line, and you really just have to say, okay, well, I'm really not ready to go on vacation. I want to work, and they need to pay you. But if you go on vacation because you want to go on vacation, then, and there's, you know, that's up to you. They don't have to pay you for that. But again, I mean, that happens not a lot. I mean, benching does occur quite a bit, but I think going on vacation, most people do want to go on vacation, so I think the employer will work with you. I
The
mean,
main thing is the benching
The
that
benching.
is happening. You know, they pay you for a year, and then you know your LCA
right.
and all this
And you're
stuff.
sitting at home,
Yeah,
you're sitting at
that's a
home.
problem.
and you're not getting paid, and they're supposed to pay you.
Yeah, and the whole reason that we're bringing all the speakers to you is don't be scared when that happens.
Right, and these are on our website too, but we have the fact sheets, and if you have questions, and you have my contact information, yes?
Yeah, and what about the confidentiality? Is it
The what?
all- The confidentiality. Is it all documented or we can directly access to you or everything?
Okay, so, in terms of when you file a complaint, the Department of Labor policy is everything that comes in is confidential. It's all protected under the Freedom of Information Act, and in an active file, nobody can see it other than myself, my supervisors, and obviously the region or the national office. Now, there's times where the violation only affects you. For example, a last paycheck situation. You know, you've switched jobs, they didn't pay you your last paycheck. In those instances, we are going to be needing permission to use name because it only affects you. Okay? So, but at that point, if you've already moved on, it doesn't affect you. Now, once the case is concluded and it's closed, then there is, somebody can petition to look at the file and see what occurred, and they do have access, but most of it is redacted. So, for the most part, when I've seen cases that have gone through the Freedom of Information, most of the particulars of that individual are blacked out. So that you really can't tell who is the person. The only thing that you can tell is what the issue is.
So when you file a complaint, she's going to investigate everybody.
Right,
She's
right.
not going to go to your employee and say, oh,
Yeah,
where is, XYZ? No, she's going to go to everyone.
right.
So
I'm gonna go
that's-
through the 16 items, and I'm gonna look at all my H-1Bs, okay? But there's sometimes where you've gone through your 16 items and you looked at your H-1Bs violations, employees, and you don't find your issue, and it only is your issue. Then that's something that we would then approach you and say, listen, we're gonna have to get permission to use name because you're the only person that is saying that they got benched on that week. And so what sometimes happens is you do get fraudulent records. It's going to say that you got paid and you're telling me, no, I did not get paid. So then that's a situation where we would have to deal with getting your permission to use name.
So if you use my name, what are the repercussions? Like, will my employee seek revenge on me or something like that?
Well, you are protected by law for retaliation. So we do talk up to them about that there should be no retaliation. And so we can only do as much as what you tell us. Like if you tell us he retaliated against me, then we have other venues. We get the solicitor of labor involved, and it could be a criminal action.
So this is the Department of Labor, right? Your employer didn't pay you, it's a civil action. He comes after you, that's a criminal case, that's a labor racketeering division. So that, and probably he or she knows that. Let's say, if he didn't pay you until that time, it's a civil action, she's dealing with.
Right, an administrative.
But he comes and threatens you, and it's no more civil, it's criminal.
Okay.
And you can call them, and eventually I think one of them will direct you to the labor racketeering division. Like I said, nobody's here to send you home at all.
Right, right. But most of the time, like I said, I think if you keep it so that we're looking at your whole picture, most employers will be like, and I just take it as like, oh, it was a mistake. You need to fix it, okay? And so I think if you take that approach, they're not going to come after you. Because that is my biggest fear, is when I leave that they're going to come after you guys. So I try to really bring down the fact that, okay, it was a technical issue, let's get it fixed, let's get this guy paid, and I don't want to hear them complaining that you said something to them, So they kind of know. But it's always a scary thing, and obviously if you find yourself in this situation, you need to call us. The person that would take the call would screen. There's a lot of questions that we have to go through for the complaint process. It goes to the regional office. The regional office decides if it's a credible complaint. They get it, they set it up, then they assign it, then it gets back down, and some investigator's going to get it, and that's going to be the person that you're going to be talking to. And obviously if you have those concerns, you want to voice those out early on so that the investigator then says, okay, this employer is obviously not going to be, happy guy, so we need to deal with him in a different way, So the more information you give the investigator, the better they can help you.
How long does the investigation go on?
It really depends. I need to give you a time frame because there's really no statute for each one. I've had cases that have taken 2 months. And I've had cases that took 2 years because we had 200 workers and they were all over the place. We had the solicitor of labor involved, and so I can't give you a definite because it really just depends on the issue. You know, and there's a lot of coordination. You have to coordinate with the regional office and our supervisors and then the investigator. So,
Remember, we are not teaching you to screw your employer. No, that's
no,
not.
no, you have to look at the facts, and you want to look at the fact sheets.
Yeah.
And obviously, if you ever have a situation, you know that the Department of Labor is there to help you. That's really what this is about, because there's a lot of what ifs. There's a lot of what ifs in our job, and so you can't think of a what if. You just gotta have, you know where your contacts are, your resources are, and if you have a problem, just reach out to us, and we can help you.
This is not about villainizing anybody. This is about creating awareness to you
Yeah.
and
Right.
you knowing, what they are there for. So,
So, okay, no more questions? Great.
Good afternoon, I'm Rick Manny with Manny and Gordon.